Hello, hello. This is Patty Joe, part 3 of the Darrell Brooks review, because I know we've probably all seen a lot of this. This is from the first day. I think they're about to bring the jury in, and the next time they take a break is quite a while into this, so I want to get moving. So here we go. He's still in the other courtroom. Surprise.
Let me actually go back on the record for a second. Mr. Brooks, when the jury comes in, I am going to read through the preliminary jury instructions. Since those have been approved by the court, if you happen to raise your sign, I'll note it for the record, but I'm not going to ask you for any type of argument on that because we've already had that opportunity to do so. It will take me some time to read through the instructions. I don't know if that will take us to the lunch hour or not. The state should be potentially prepared to go through its opening. Mr. Brooks, if we do get to that point where the state is giving its opening and you have an objection, you need to write down the...
Oh, I forgot to say this. I really would like to thank everybody for the comments. I saw one in particular agreeing with my cherry picking the sovereign citizen rhetoric. So I do read them. Going to read them a little bit more thoroughly later, but thank you so much for joining me.
The objection, in addition to raising your hand, and I will rule on the objections after the closing statement. So you must write down the basis for the objection and what you're objecting to, in addition to holding up your sign. That's the procedure that we will follow. All right, now we're on a short break until the jury comes in.
See, I told you. That should say interruption, not objection. Because he objects to everything. So it should say interruption. Shouldn't it, Harley? Yeah, well, they're off the record now. I would love to have the audio of that extracurricular stuff. I think that would be absolutely epic. Because look at him waving his arms and acting like a... well, I think we all know what he's acting like. I don't think we need to...
Courtroom when it is necessary for me to
reading the
arguments from the parties. If you come in contact with the parties, lawyer...
I know I'm stopping this a lot, but let's go back to all of the criticism that she allowed him to do certain things that were, interruptive of the court and things like that. And I think what she really was trying to do was make it absolutely as fair as possible. And what she's done here is you can see that selectively during times when he wants to interrupt. Of course, that objection, I wish I knew how to edit it to say interruption. But she does do it with him out of the courtroom. So I think she did do a lot of selective putting him over there.
Or witnesses, do not speak with them.
I think he helped her do it,
For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by other means. If anyone does so despite you telling them not to, you should report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report it to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. You are not required to, but you may take notes during the trial, except during the opening statements and closing arguments. The court will provide you with the materials. In making notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and testimony introduced at trial. During the course of a trial, the parties may refer to or use police reports with witnesses. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to police reports. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that the defendant's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. All parties in the courtroom, including the attorneys, the litigants, witnesses, the judge, the jurors, and those in attendance are expected to conduct themselves appropriately and in a manner that avoids creating disorder or disruption, as well as conduct themselves in a manner that demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. At the moment, Mr. Brooks is appearing from another courtroom. This must not influence your verdict in any manner. Evidence is defined as, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room.
I am sorry to stop this. I am reading a highlighted comment. Thank you so much for commenting this. Everybody can find it, I'm sure, for themselves. I'm not going to call out names or handles or whatever they're called. Says, isn't it interesting how DB can snap right back into full focused lawyer mode when it's something that he has vested interest in? This is a clear indication that his disruptions are purposeful, meant to only disrupt. Judge Darrell, Judge D, knew exactly how he would be representing himself. Yes, and that's what I'm saying. She actually had and learned through the trial some of his different behaviors. Absolutely. What would happen if a woman took her shirt off and wore jail attire? Oh my goodness. Well, that's interesting too. That's interesting. So yes, I'm agreeing with everyone. Thank you so much for participating. This is exactly what I need as well. People thinking that way I think, maybe. I do have to say, going through these, and I really want to listen to her speak because she's such a great speaker. Listening to her jury instructions. I was on a jury recently, and it was such a cool case, and I'm not going to go into it here, but maybe I'll do like just my mug up there telling you what the case was, because it was so interesting to do that. And I'm not one for being in court, considering my past professions.
Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct
CSI
or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offenses before you may find the defendant guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses, and to the admission of other evidence, which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of a party, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and of the weight of the evidence. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the parties are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about.
I am so glad that I'm actually re-listening to this because, and I'm trying to take some really good notes. She did a few really good things that I observed, which was defining everybody's role, and that the jury was the body who's going to decide whether the facts were the facts and what the truth is. This is so cut and dry, I think we all know, but what she's saying now is she said, for credibility of the witnesses, which is something he attacks over and over again, or attempts to attack over and over again, was interest in the result of the trial. And that's interesting that she did, that there is a mechanism for that, and that he lobbed onto it. So he must have been listening to his former legal staff all along and cherry picking those things as well as the sovereign citizen details, because he so drives into this. Every time there's an officer on the stand, every time there's a detective on the stand, every time there's any really witness on the stand, what are you getting out of me going to prison? Interesting. He definitely did things here.
Reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic.
Yes.
There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. The defendant is charged with 6 separate counts of first-degree intentional homicide, use of a dangerous weapon. The first count of the information in this case charges that
my mouth goes dry just to hear that.
Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Virginia Sorensen with intent to kill that person and while using a dangerous weapon. Contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The second count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Leanna Owen with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The third count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Tamara Durand with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jane Coolidge with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The fifth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Wilhelm Pospel with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jackson Sparks with intent to kill that person and while using a dangerous weapon, contrary to section 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The defendant has entered a plea of not guilty to each.
Maybe I'm missing something, but didn't she say that she would know that the objection sign would mark the time and he should write it down and it would be addressed after that? She was not going to stop, but he keeps waving as if he's going to stop. I don't know what, but disrespectful.
Each one of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of any count of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present with respect to that count. 1. As to each count, the defendant caused the death of the victim named in that count. Cause means that the defendant's acts was a substantial factor in producing the death. 2. As to each count, the defendant acted with the intent to kill the victim named in that count. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or for even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The information alleges not only that the defendant committed the crimes of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree intentional homicide, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count one, you should find the defendant guilty of first-degree intentional homicide as charged in count one. If you are not so satisfied, you must find the defendant not guilty as to count one. If you find the defendant guilty of count one, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon?
I'm going to skip ahead a little bit.
If you are satisfied,
because this is going to be repetitive.
Contrary to Section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 38th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Grayson Urell under circumstances which show utter disregard for human life and while using a dangerous weapon.
So she goes through all the 76
Contrary to
counts.
Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 58th count of the information in this case charges that Darrell E. Brooks, on or about
Now, it's my understanding that, obviously the first six are very obvious. The other ones were people that he physically injured, but endangering does not. He was also accused of endangering, which does not mean he had to physically hurt them to endanger them. So I can endanger you by, I don't know, setting a fire or something like that. But if you don't get hurt, I still endangered you. So I could still be guilty of that crime. I'm assuming that's what that means. Anybody with some legal background can correct me or educate me. That would be fabulous, but I think I'm correct. But they decided to only charge based on actual physical injury. So if they were endangered, because everybody at that parade would have been endangered, that would have been thousands of charges. So they decided to clean it up and only do certain things. And so being respectful to the entire community that was really, really injured, even to this day. I'm still talking about it. So, but respect to all of those who were injured and those not named in this case who were injured. So I hope I popped it over to where she's finished reading all of the charges, including the ones for the battery, directly to Eric Patterson.
Tell you what, I'm going to let you all stand while I figure out if there's a typo in my instructions, because I want to make sure I read them correctly. So go ahead and stand while I do that.
Oh, goodness, gosh, I need to stand too.
All right, go ahead and have a seat. Just so the record is clear, I'm just going to start over with the use of a dangerous weapon part of this instruction. The information alleges not only that the defendant committed the crimes of first-degree recklessly endangering safety, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree recklessly endangering safety, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? Before you may answer the question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree recklessly endangering safety while using a dangerous weapon. If you are not so satisfied, you must answer the question no.
I think that was the same.
If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 7, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 7. If you are not so satisfied, you must find the defendant not guilty as to count 7. If you find the defendant guilty of count 7, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 8, you should find the defendant guilty of first-degree recklessly endangering safety as
Do we find it ironic that this is taking longer than they took
charged
to
in count 8? If you are
deliberate?
not so satisfied, you must find the defendant.
Let's go forward because this looks repetitive too. So
27.
27.
If you find the defendant guilty of count 27, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? 2. Standards of courtesy and decorum for the courts of Wisconsin would also direct you to. If you find the defendant guilty of count 34, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 35, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 35. If you are not so satisfied, you must find the defendant not guilty as to count 35. If you find the defendant discussion prior to the court's approval.
Okay, there you go.
Mr.
So don't
Brooks,
start
I will
deliberating.
once again advise you that you are welcome back into this courtroom should you wish, if you are able to conform your conduct to the rules of courtesy and decorum that you have been previously been advised about. Once again, direct your attention to SCR Chapter 62, Standards of Courtesy and Decorum for the Courts of Wisconsin. Would also direct you to Illinois versus Allen. That's the case I've been relying upon for the procedures that have been employed. Mr. Brooks is holding up the objection sign. I don't have anything in writing, which is the procedure that I told him he needed to follow in terms of me addressing any objections. So if he wants to,
Because he wasn't listening.
write down what his objection is, and we'll file that. We'll also indicate the time. If appropriate, I'll take that up after the break, but at this point I will be breaking for the noon hour, for the lunch hour. It's 12 noon. Let's be back here at 1 p.m.
And could he also have the opportunity to change into his street clothes if he wants during the lunch break?
Absolutely, during the lunch break, I'm told, will be seen by jail medical staff for the concerns that he's raised. He will be given the opportunity to change into his street clothing, should he choose. Of course, when he comes back, once again, invited back into this courtroom, should he choose.
Yes, and I would just observe for the record that for about the last hour while you were reading the jury instructions, Mr. Brooks did not appear to be in any physical pain or medical distress. He's
Snap.
been moving around freely, shuffling his papers, reading his documents, actually behaving quite appropriately, standing quietly, oftentimes with his hands folded, and at times listening to the court, and at times it appears he's working or looking at materials on his table.
All right, thank you. I appreciate that. We are in recess.
Thank you.
Well, well, well. That had to be, I'm sure he would have had something to say about that. Okay, so this goes. I'll find the next. I'm trying to track where I am when I stop these things. When I want to restart. Okay. Stop. I hate my mouse.
All right. Thank you, everyone.
Okay, there we go. And that's going to be 442.05. Okay, so that was the jury instructions, and I know I bopped around on that because it was so repetitive, but I think we get the idea. And like I said, I did notice that, you know, some of the things I'm making connections on that I wasn't making connections on before. So I'm hoping maybe me reviewing this in this slow manner, just piece at a time, is going to get me, you know, the I don't know if I want closure or just want understanding or understanding of other cases, because I just find this so absolutely cut and dried. No doubt in my mind. In fact, I couldn't even address it until I knew what the verdict and the sentence was going to be, because I was just so like overwhelmingly connected to some of the things. I was in a marching band. I was in a drum corps when I was younger. I did parades with dance teams as well. So I did a lot of that. So that touched me very deeply. Just the small town thing. I used to take my kids to those things, and had something like that happened, I had no idea how I would react as a first responder, as someone working for the fire department, as a paramedic for 20 years. I definitely do know that I've dealt with multiple casualties, but this is mass casualty. I haven't had one mass casualty in my career, and I just know that it affects you. It affects you. It's emotionally draining. I know you're not like totally connected to all of it, but these people would have been. That's their community. So I have no idea. Like that's incredible. So a lot of respect to everybody involved. Again, I'm going to stop it here for now, and we will come back. Thank you so much
back on the record.
For your attention and bearing with me. Maybe you can get something out of this as well. Bye.